Hello, my name is Mr. Jordan. I am a social studies teacher at St. Elizabeth School, where I teach United States history, government, and law. You might also know me from spending 4 months of my year coaching one of the top mock trial programs in the state of Delaware. Now you might be asking yourself, why is Mr. Jordan talking to me in my Brit Lit class? And the reason for that is I'm here to talk to you about the law. Specifically, the differences between criminal and civil law. Now, the differences between criminal and civil law are numerous. One of the key differences is the fact that in a criminal case, there is the potential for the penalty of prison time. So there are legal consequences for somebody who faces a criminal trial. The criminal trial is brought about by the state, so it is not a private citizen suing another private citizen. Instead, it is the government, whether it be the federal or state government, levying charges against an individual. Now, a civil trial involves one party filing a lawsuit against another party. This means that they are trying to seek some sort of damages based upon some sort of wrong. They may be seeking financial damages. They may be seeking something called an injunction, which is where one party requests that another party stop doing something. Now, the major difference between a criminal and civil trial is the fact that there is a different burden of proof. So a burden of proof is what the prosecution or plaintiff needs to prove in a particular trial. In a criminal trial, the burden of proof rests with the prosecution, and the prosecution must prove beyond a reasonable doubt. This means that the story that the prosecution is telling is the only viable thing that could have happened, that there is not an ounce of reasonable doubt that the person committed a crime, specifically the crime in question. Now, this doesn't mean just any old doubt. This excludes aliens coming down from the sky or something absurd happening. It has to be a doubt that falls within the realm of reason. So in a criminal trial, the burden of proof is beyond a reasonable doubt. However, in a civil trial, the burden of proof belongs to the plaintiff. And the plaintiff has to prove by a preponderance of the evidence. By a preponderance of the evidence means that the story that the plaintiff is telling is more likely than not to be true. That it is just a tip of the scales more likely. That it is 50.000001% more likely. Just ever so slightly more likely to have occurred than not to have occurred. Now, I've mentioned in a civil trial the term plaintiff. The plaintiff is the party that files a lawsuit against a defendant. So a plaintiff is the person who has a burden of proof in a civil trial. Their counterpoint in a criminal trial is the prosecution or the state. But in a civil trial, it is the plaintiff, Plaintiff, that has to prove that there was some sort of wrongdoing. It is the defense, who is representing the defendant, who has the opportunity to refute what the plaintiff is saying. Now, all of this happens in front of a jury. So there is a jury in a criminal trial, and there is a jury in a civil trial. Now, in a criminal trial, the jury will take all of the evidence and see whether or not the prosecution proved what they were meant to prove beyond a reasonable doubt. In a civil trial, the jury will understand and take the total weight of the evidence, and they will make a verdict. They will reach a verdict about whether or not the plaintiff has proven by a preponderance of the evidence that the defendant is liable. So in a criminal court, you are guilty or not guilty. In a civil court, you are liable or not liable. These are some of the many differences between a criminal and a civil trial. If you have any questions, please let me know. Please let Miss C know. Please let anybody with any sort of knowledge know. Have a wonderful day. Take care.